So in the last video, we were looking at the morality and rationality of suicide. And as I stated, the reason we did this is because it seems like a lot of the big philosophical and moral questions that pertain to physician-assisted suicide really turn on our understanding of whether or not suicide itself is ever morally permissible and whether or not suicide itself is ever rational. As I said last class, there seem like there are a number of arguments to show that suicide could be immoral. And we saw that even with that being said, that suicide may be immoral in general, there could be certain circumstances in which suicide might be permissible. For instance, if a person is in pain and suffering, an extensive pain and suffering, and in those situations where their suffering can't be alleviated and they're bound to die, they're going to die. And those might be cases where a lot of people feel like, okay, in these few cases, suicide is not immoral. And we could have, and I didn't spell this out in the last video, but we could have spelled it out too when we talked about the rationality of suicide, that even if in 99.9% of cases suicide seems like it's irrational, you might allow it and say, well, actually, in cases where a person is terminal and suffering, suicide in those cases might also be deemed to be rational. That's the way the argument typically goes. Now, what we're going to do in this lecture is we're going to turn to looking at a number of one legal argument. We're going to turn to the legal questions that pertain to physician-assisted suicide. We've been looking so far at moral questions, but what about legal arguments for whether or not physician-assisted suicide should be lawful or unlawful? And before we get to this, I do want to spell out two things that are important and justifications for physician-assisted suicide. And one of the main justifications for physician-assisted suicide stems from the pain and suffering of the person or the patient involved. And we've seen that when we talked about the morality of suicide and the rationality of suicide, this is one of the key components or key justifications that would render suicide itself morally permissible, perhaps, arguably, and it also might render it to be something that is rational in some circumstances. But something else that I didn't say very much about in the previous lecture is the fact that a lot of people would defend assisted suicide and even suicide more generally, not even assisted suicide. They might defend it on the grounds that it's your body and you can do with it as you see fit. This is actually one of the main arguments that people do offer in support of physician-assisted suicide, or just suicide itself. You'll see this argument come up a lot of times and say, hey, it's your body, your life, you can do with it as you see fit, and that includes ending it. Notice what's interesting about this particular line of justification is that once you say that the justification for suicide or any form of assisted suicide turns on bodily rights, then the pain and suffering of the individual involved really don't seem to be that relevant anymore at all. Because if it's my body, my right, I should be allowed to do with it as I see fit. Why do I have to be suffering? Why do I have to be in pain? Why do I have to be terminal? Regardless if I'm terminal, regardless if I'm suffering, it's my body and my life, and I should be allowed to do with it as I see fit. Now, a host of different questions come up when we talk about problems for pushing this particular justification for suicide and physician-assisted suicide. And the key question that's going to arise when we talk about using autonomy or bodily rights as a way of justifying suicide is whether or not the person who's offering this rationale is in fact competent. Is someone competent if they want to kill themselves and everything in their life is going splendidly? At least at a first pass, you'd really question whether or not they were competent. And remember when we talked about Kant, we said that in order to do something that is of your own free will, you have to be of sound mind and judgment. And so whenever you see people push this line of argumentation and they'll say, look, you have a right to kill yourself you do nothing wrong. You should be allowed to gain access to drugs to kill yourself. Have a doctor prescribe those to you, and you do nothing wrong. And this is all justified on the basis of bodily rights and individual autonomy. That all might be well and good, but there are going to be questions here as to whether or not a person is of sound mind and judgment when they're asking for certain kinds of medications to end their own life. So I mention these two here because when we look at most philosophers and what they have to say about physician-assisted suicide, what I find really interesting is that most support physician-assisted suicide. And the reason they support it is because they see it as a individual rights issue. And most philosophers will say, it's your body, your life, you have a right to do with it as you see fit, and that includes killing yourself. So I think as far as philosophical justification goes, even though the pain and suffering is one that you hear a lot, in common discourse about it, I feel like in the philosophical literature, what you see more often than not is people pushing the line that it is physician-assisted suicide is justified on the basis of just strictly bodily rights, and that's true regardless of the pain and suffering. Now, with all this being said, I want to turn our attention to looking at legal arguments for justifying or for allowing physician-assisted suicide. And I had asked you guys to read, it was a philosopher's, it was called the Philosopher's Brief. It was an amicus brief, and some of you might not be familiar with what an amicus brief is. But an amicus brief is basically whenever someone who is an expert in a particular area has something important to say about a court ruling or court judgment, they'll write up their expert opinion and submit it to the court for them to be guided and have some assistance. It's called an amicus brief. Amicus stemming from the root word that we get our word amicable, mean friendly. Amicus brief, it means a brief that's written by a friend of the court. And this particular brief was written by a number of important philosophers and lawyers. As you can see here, in 1997, the Supreme Court was deciding a few cases that pertain to physician-assisted suicide. And in this amicus brief, they argued for a legal right to acquire physician-assisted suicide. And what they offer is basically a case-based argument. What they're trying to do here is argue that, I've said this before, every single state in the United States says that physician-assisted suicide, they don't allow it. Strictly speaking, on the books, they don't allow it. Back in the 1997, I think only 1 or 2 states allowed it. And what the philosophers wanted to argue is that state laws that prohibit physician-assisted suicide, those laws are unconstitutional. And what they wanted to do was to offer what's called a case-based argument. And this is something that you're probably very familiar with from having watched TV courtroom dramas. You may have seen in a TV courtroom drama or a movie or something like that, where a lawyer will appeal to some past case, and they'll say, well, as the court ruled in Club Soda versus Dakota, blah, 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 and they'll use this past, I don't know if there is a Club Soda versus Dakota, I just made that up, but they'll use this past case as a way of establishing their current point, because the thinking is, well, if the past court decided X, then that's the law of the land, and that's how we're going to rule in the present case. And so what they do is in their argument to show that state laws that restrict physician-assisted suicide are unconstitutional, they appeal to a number of past cases. Now, in none of the past cases, none of them involved physician-assisted suicide. So what they're trying to do is appeal to cases that establish a principle that can be applied to the case of physician-assisted suicide. And what they argued is that in these past cases, the court basically argued that a person has a right to make medical decisions that are of most intimate and personal choices that are central to personal dignity and autonomy. And so you can see here already their way of defending a right to physician-assisted suicide is going to be based on individual freedom, individual autonomy, and is actually not going to be based on the pain and suffering of the person involved. So they mention a couple of cases, but I'm going to highlight two in particular. And one of those is the decision called Planned Parenthood v. Casey. And this was actually a court case that involved abortion. And what the philosophers argued, they said, hey, in Planned Parenthood v. Casey, the court upheld a woman's right to have an abortion on the ground that abortions fall within the parameters of personal and intimate decisions. And that's really critical because they're saying, hey, look, this is what the philosophers are saying. They're saying, hey, look, in the past, the court said any decision that involves, lies within the parameters of personal and intimate, a person has a right to make those, and the state doesn't have a right to interfere. And then they said, hey, look, physician-assisted suicide, well, that's certainly of a personal and intimate decision. And so since the court has protected our right to make personal and intimate decisions, this should also protect a person's right to end their own life. This is something else the court said. They said, such a decision originates within the zone of consciousness and belief and involves conduct in which the liberty of the woman is at stake, in a sense unique to the human condition and so unique to the law. Another quote, they said, a woman's decision to have an abortion involves, quote, the very destiny of the woman and is inevitably shaped to a large extent on her own conception of spiritual imperatives and her place in society. And notice here, again, they're saying abortion is protected. This is what they ruled in this case. This is what the Supreme Court ruled in Planned Parenthood v. Casey. They said a woman has a right to an abortion because it is inevitably shaped to a large extent on her own conception of her spiritual imperatives and her place in society. And that it involves the very destiny of the woman. Well, you can say all those same things about physician-assisted suicide. I mean, certainly the decision to kill yourself involves your own destiny. Certainly the decision to kill yourself is shaped by your own conception of your spiritual imperatives and your place in society. And since abortion is protected for these reasons right here, we can apply these reasons to assisted suicide, and so it too should be protected. This is what the philosophers were arguing. They said, this is continuing, this is just a number of quotes from what they said. They said, the court ruled in Planned Parenthood v. Casey that, quote, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. And this is the key one. The court said, and this is, again, what's in quotes here, what's been in quotes from all of these, is from what the Supreme Court actually wrote in Planned Parenthood v. Casey. What the court said is that matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. And that's really the key line here. What the court said is that choices that are of a central to your personal dignity and your autonomy are central to the liberty protected by the 14th Amendment. And if that's true, then certainly physician-assisted suicide, this is what the philosophers argue, should also be protected. Because certainly the decision to kill yourself involves your notion of personal dignity and autonomy, and so therefore it should be protected by the 14th Amendment. So this is one case that the philosophers cited in support of a legal right to physician-assisted suicide. They also looked at another case, and this one is a little closer to physician-assisted suicide. It was a case, Cruzan v. Director, and it was actually, I believe, it was the very first case that involved a patient's right to die. And what had happened is that Nancy Cruzan, had actually been in a car accident. As a result of that, she suffered brain trauma, and she was in a permanent or persistent vegetative state. She had a feeding tube inserted, and her family wanted to pull it. She was in a coma, and she was in this for weeks on end, and her family wanted to remove it, but the state, I believe it was of Oklahoma, said that they wouldn't do it without a doctor's order. Without a court's order. And so then there was a case, her parents filed suit, it made its way up to the Supreme Court. And basically what the Supreme Court did is they upheld a a competent patient's right to refuse treatment. And then they also further held that in this case, well, she wasn't competent, but her parents were speaking on her behalf, that it was a person's right to refuse any kind of treatment they wanted, and that even if that involved them dying. And the parents said that, basically she wouldn't have wanted this, that they're just acting on her behalf as to what she would want. And so it was ultimately decided that even in this particular case, you had a right to refuse treatment, even if it ultimately led to your own death. And what the court said about this, and this is what's really interesting, is that they said that such a choice is of a deeply personal nature and is inextricably intertwined with one's notion of self-determination. And here's the thing, you can say the exact same thing about physician-assisted suicide, that it's of a deeply personal nature, that it's inextricably intertwined with one's notion of self-determination. And so what the philosophers argued, basically in a nutshell, is that the court has routinely and consistently protected a person's right to make decisions that are of a deeply personal nature, that involve one's notion of self-determination, that are a function of that person's notion of personal dignity and autonomy. Those rights those decisions that involve within this parameter are protected by the 14th Amendment. Therefore, the decision to kill yourself should also be protected by the 14th Amendment, because all the same criteria that are all the same conditions that protected a right to choose, to refuse treatment, all the same conditions that protected a woman's right to an abortion, those same conditions apply to physician-assisted suicide. So this is basically how the philosophers conduct their argument. Now, once they conduct it, and I think that side of the argument is pretty strong, once they propose this, then they go on to deal with possible objections to their argument. Because whenever you're constructing an argument, as we've seen, there's always the pro side, but you also have to look at the negative side. And so that's what they want to do next, is they present their positive case, but then they also have to present their negative case. And what they present are what they call slippery slope arguments. And what a slippery slope argument is it's basically the idea behind a slippery slope is that if you allowed for, let's say, X, that would lead to Y, that would lead to Z, and Z is something we don't want to allow. So the basic idea behind any slippery slope argument is that once you start down a certain path, it's going to incrementally lead to a place that we don't want to allow. And they present two versions of the slippery slope argument. The first one is called the theoretical slippery slope argument, and the second one is called the practical slippery slope argument. And these are both objections to the philosopher's case, their legal case for defending physician-assisted suicide. And when looking at the theoretical slippery slope argument, what this basically says is just this, is that if you were to allow physician-assisted suicide for the reasons that the philosophers are offering, if you were to allow it on the grounds that it should be protected because it's of a deeply personal nature, it's a person's right to choose, it's a liberty that's protected as a function of the person's autonomy, is that if you allowed it for those reasons, then you could not limit assisted suicide to just the cases that most advocates of a right to die movement want to limit it to. So let me explain that in a little more detail. So most people who defend physician-assisted suicide, as I've said before, they want it only for the terminally ill and only for those who are in unremitting pain. The vast majority of people who defend physician-assisted suicide, they don't want it for people who are perfectly healthy. They don't want it for a 16-year-old whose girlfriend has just broken up with him. They don't want it for someone who is suffering from paranoid schizophrenia, who can't speak for themselves. They don't want it for just a 25-year-old who lost their job and are frustrated with their life. They don't want it for grandma who's suffering from dementia and Alzheimer's. They don't want it for people who have 5 years left. Most of the advocates of or the champions of the right to die movement want it, like I said, only for those who are terminally ill and only for those who are in unremitting pain. And so the problem here is that once you say that autonomy is the basis, once you use autonomy and bodily rights as a way of justifying physician-assisted suicide, you're not going to be able to limit it to those patients who are terminally ill. And you're going to have to extend it to everybody else, because if it's all about bodily rights, why do I have to be terminal? Why do I have to be in pain? And so once you go down this corridor and you say we should have physician-assisted suicide because this is a constitutionally protected right, then you can't limit it to just those clear cases where you want it to allow it. Not only that, but what people worry is that once you allow physician-assisted suicide, you'd also have to allow euthanasia. Because if if physician-assisted suicide is protected because it's a function of a person's autonomy and it's an extension of their bodily rights, then why can't someone else kill me if I ask them to? I mean, isn't that also an extension of my autonomy? Isn't that also protected by my bodily rights? If I want you to kill me, why shouldn't you have that right? Why shouldn't I be able to grant you that right to kill me? And that's, again, something that most of the people who defend physician-assisted suicide, they don't want at all. They want it only physician-assisted suicide. They don't want euthanasia. So there are really two things at work here that most advocates or most people who defend physician-assisted suicide don't want. They don't want it for people who aren't terminal, and they also don't want euthanasia. But the question is, how do you limit it to just terminal and just physician-assisted suicide once you make everything all about autonomy? And here's what the philosophers say. Actually, sorry, I got a little ahead of myself. And there is some, proof in the pudding, so to speak, because there are people who actually say that you can't maintain this line between the terminal, the non-terminal, between physician-assisted suicide on the one hand and euthanasia on the other. There's a Swiss organization known as Dignitas, and they believe that anybody, if you're healthy, if you're not healthy, you have a right to die, and sometimes that might even involve being euthanized. And Dignitas, they believe that anybody who's a competent adult should be allowed to die. And in fact, they've assisted, I have up here, this is actually a couple years old, it's probably a higher number than that by now, but they've assisted about 1,000 people in ending their own lives. And one of the more controversial cases involved an elderly couple who had made a suicide pact with one another. And basically the couple said, well, the wife said to the husband, if you die first, then I'll kill myself. And the husband said, well, if you die first, then I'll kill myself. And I think the husband may have passed away, I forget, but the husband may have passed away. And the wife, perfectly healthy, not on death's door by any stretch, she wanted to die, and Dignitas, they came and they assisted her in dying. And the reason that Dignitas thinks that anybody should be allowed to kill themselves, or anybody should be allowed actually to even be euthanized, is all because they focus solely on autonomy and individual rights. And for them, they say, look, you're a grown-up. If you want to do with your body, if you want to kill yourself, you should be allowed. And we do nothing wrong with helping you if you want to. And in fact, you're a grown-up. If you want us to kill you, we should technically be allowed to do that. Because think about it like this, too. If you were to allow physician-assisted suicide and not allow euthanasia, then it would be a little perverse in a way, because somebody who was really, really bad off might not be able to kill themselves. Somebody, for instance, who couldn't swallow anything because of cancer, they would have to have a feeding tube inserted into them. So let's suppose someone couldn't swallow anything and didn't have the strength to, hit a button to kill themselves. They might require somebody else to actually inject them with a medicine to kill them. And if you only allowed physician-assisted suicide and you didn't allow euthanasia, then basically what you'd be saying to that person is, you're so bad off, we can't kill you. That would be wrong to kill you. If you'd only been a little better off, then we could have let you kill yourself. Which that seems a little perverse in a way. But the bigger point here is, once you go down the route of saying it's all about individual autonomy, then there's really no good justification to, limit physician-assisted suicide only to people who are terminal, and there's really no good justification to say you shouldn't allow euthanasia as well.